Preliminary Sandoval means all the past crimes that you have done, and you have a guy with a long rap sheet or a lot of crimes that he has done and convictions. They can use that against him if they take the stand. That's the good thing about Sandoval. All right, let's say I have a history. I'm on trial, and I choose to take the stand. Sandoval allows the district attorney to ask me about my priors, everything I've done wrong. Priors means like every my arrest, my conviction for whatever the hell I have.
And just he's saying Sandoval. That's the
case.
That's the case that decided that this is how it's gonna work moving forward. When he says Sandoval, that's just short term for citation right there.
There's people be Sandoval.
Jabril pointed first, so he'll write that one.
Yeah. Jabril won't like this. Well, no, but it's the way it's easier to explain is like beginning of trial, Sandoval, Molyneux, then Voidier. Like that's why I want to make it clear. Sandoval, Molyneux, Voidier.
So Sandoval goes
Molyneux,
if you testify.
Yeah, if you testify. Molyneux is the instances where the prosecutor can actually bring past things that you have done that are bad.
Right. Not necessarily crimes.
Not necessarily
but
crimes.
Bad acts.
Behavior, bad acts, exactly what F says. Into the trial without you testifying.
All right.
That's the key thing.
So before we get to when they can do it, why can't they typically do it? What is the court system worried about?
Well, the court system is worried about propensity evidence.
And what is that?
Propensity is the key word. Propensity means if you do something wrong, that's likely for you to do it again and again and again and again and again.
And the court system wants to avoid it.
Avoid it. Yes.
And why do they want to avoid
For
it?
prejudice.
Yes.
They don't want jurors to be prejudiced just because, like, oh, this guy, he went in the store and acted crazy 5 times before in the past. So he's in the same store this time and on trial, so he must have done it again.
You don't want to convict a person based on that. That's correct. You don't want to convict and say this person is guilty just because he's done it in the past.
Basically, you don't want to say this guy's a dickhead in this situation because he was a dickhead in the previous situation.
Yes.
Correct. You want to try him on what he did right now.
Then, yes, exactly.
Beyond a reasonable doubt, which
Yes.
is the standard we haven't established. But basically, you want to sit there and say, you want a jury to believe that this person did this thing on this date, the specific crime that they're being charged with. You want them to believe it beyond a reasonable doubt. And you don't want them to sit there and go, he's typically committing crimes. If beyond a reasonable doubt, which you can't actually quantify, is 80% or whatever it's conviction, convincing of yourself, right? You don't want to sit there and go, I'm not there, but he's a criminal, so he's probably
exactly. You don't want to use that against them in this trial. You want a juror to be like, okay, this is where it starts, this is where it ends. When he got arrested to when he's facing trial, you don't want him to go before when he got arrested for this crime.
But you can, under certain circumstances, which are?
It's called. I call it mimic. I don't know if you guys have heard
I've
of
heard
mimic,
that. Yeah.
right? Like it's like all defense attorneys here mimic.
Motive,
identity, mistake or absence of, right?
That's called prep.
Intent. That's called mimic. Intent and a common scheme or plan.
Okay, so let's try to go through some of these.
So, what was the first one I said? No. So mistake or absence of is mistake or absence of is like when you say there wasn't me, but you've done it in the past. Your defense is gonna be a mistake. Like, is somebody else done me? Boom, mistake. They can. Let me just think about this. Like, for example, you haven't cashed a forced check. You've done it before, and you're like, okay, that's not a mistake because you've done it before. They can use that against you.
Basically, the argument is that you're sitting there going, someone could be caught in this situation by accident, but you don't fit that criteria because you got caught doing it legit. Like you got caught and convicted previously, or caught, at least arrested several times. That it's because you've been in this situation so many times.
You don't know how
it's no longer an accident.
Yeah, like you don't know how it's done. For example.
Exactly.
That's it. Identity, we all know what it is.
Well, sure.
Identity. Okay, identity is like it wasn't me. Like Shaggy.
Yeah.
That's identity.
And how would they get
How would they get
a prior bad act in?
You can say, I was not the one robbing the supermarket, and it's a video of they see you, and it's like the same thing. You look the same.
You've been there
went the
previously.
Yeah, exactly.
Okay.
All right. Motive. Motive is, you have a motive to do this one time. For example, I have a motive. Let's take it up a notch. I have a motive to kill my last wife because of her life insurance. And then you do it again. Boom. Motive. You have a motive to do it a second time. They can introduce that again. They have to show a lot more than that, but that's in essence what it is.
Okay.
All right. Intent. when you say I did not intend to steal that from the store.
Then
But
you
you
can bring in
have
the
done
fact that
it
you have the
before.
life insurance.
Because it's the same. You can say the
Yeah.
same thing about
Yeah.
that. Yeah, I did not intend to.
They're similar. They're all
It's very similar. And the common scheme or plan is, we all know, it's easy. Serial killers. Common scheme. You
Or
leave-
bank robbers.
Bank robbers. Serial killers, you keep, like a little something about someone you kill, and you keep, it's common scheme. They have the signature. The Zodiac killer, they have it's the same scheme. They do it the same
They
every
commit- they com-
single
they commit
time,
a
the
certain-
same crime.
Right. They commit
They-
a certain crime. A
Like
certain
you're
way.
basically I want to like explain it further. Is that they're gonna allow this evidence in, right? Because what they're gonna say is that we don't want you to judge him that he robbed a bank previously. What we want you to consider is that when he robs a bank,
This is how he does.
this is how he
Yes,
does it.
exactly.
He gets a note. He tries to keep violence out of it.
He
by-
signs the same signature.
Yeah.
It's
Or like a good example
Yeah.
is like you give a note saying, "I have a bomb. Give me the money. Don't say anything." Right? That's a very specific way to commit a bank robbery. Right?
Yeah.
You avoid having to bring a gun. You avoid all this stuff. You just make a very serious threat. That's how you commit it. You hope the person that you give it to like freezes
Yeah.
and just hands you money. That's the way you. That's the
You
way
do
that-
things.
That's the way you do things.
And
And
they
because
know
of
it.
you've done it in the past and you did it in this case, the prosecutor is basically arguing that's we're not saying convict him because he did it. He's committed a crime. We're
But just
saying
keep in mind that.
that this is how he does
I mean,
it. It's
in
consistent
essence-
with what he did in the past.
In essence, that's what they want you to. I mean,
Yeah,
it's still.
They want
All I
you
know
to
is
do
very
that.
prejudicial.
Yeah,
in
it
many
is,
ways.
but-
that's their way they get it into the case without our client testifying. The way they want to,
Okay.
So but it's a way. So then, okay, we.
All right.